probable
Yes,
cause.
yes.
All right.
Yes, please.
All right.
Your Honor.
Good job.
Thank you. Thank you.
And I'm going to tell you, look,
KEMP.
okay. So what's the word, Thunderbird?
So upon watching the video, I agree with the offense fee. It's not really clear. It's all happening at once where you see one
All right,
moment.
folks, buckle up. This case is not your typical courtroom drama. What starts as a desperate 911 call for a mother struggling to breathe spirals into accusations of assaulting emergency responders. At the heart of this case is a son, frantic, emotional, and trying to protect his mom. But did he cross the line when things got physical? The prosecution says yes, that he grabbed an EMT's arm and disrupted life-saving work. But the defense, they argue this was nothing more than a blur of chaos, a misunderstanding in a moment of panic. The real question, where do we draw the line between a son's instinct to protect his mom and the law's demand that responders be allowed to do their job? Stay with us, because the testimony, the video evidence, and the judge's final decision will absolutely leave you questioning how you would have acted in this moment.
Stretcher because they're trying to make sure that their mom is fine. What?
Notice how the defense is framing this. Chaos, panic, confusion. And let's be honest, anyone who's been in a medical emergency knows how quickly things spiral. But here's the issue. The law doesn't always bend for panic. If you grab or interfere with EMS, even unintentionally, prosecutors can push for charges. The officer admitted he couldn't clearly see what started it. That's key. If even law enforcement can't tell who pushed first, how strong can the state's case really be? What do you think? Was this a son desperately trying to keep up with his mother's stretcher? Or was it an actual obstruction of emergency workers? Drop your thoughts below, because this is where jurors and viewers usually split right down the
Officer,
middle.
he just grabbed it, and the officer grabbed him at that point. So the reason why it's not really clear how quick it happened. On the video, it looks pretty quick because the officers grabbed him immediately.
But but the issue is that the officers arrive at the scene when there was already an incident occurring. They don't know. The officer can't state what happened initially.
Right, but the issue here is that as it's played, it's like the grab of the arm is that interruption or just disruption of the EMS trying to get the mother onto the gurney. And it's not necessary that the defendant intended to do that. It's just that there was that
This is
disruption.
a specific intent crime, so he has to
Here's where things
specifically...
get technical. The difference between specific intent and criminal negligence. Specific intent means you meant to interfere. Negligence means you should have known better. The prosecution is going with negligence, an easier charge to prove because they don't need to show he had malicious intent. But pause here. If negligence is the standard, then nearly any emotional reaction during a crisis could be criminalized. Should we really hold family members to the same calm standard as trained professionals? Or should the court recognize that in high-stress medical emergencies, emotions are bound to spill over? This is the razor-thin line being debated.
I think it's enough. I mean, even if they were to give us an offer, if we take this case literally to trial, the mom is going to testify as to what happened, including the brother and the dad, because they were also witnesses, which I spoke to all of them. I mean, I'm saying, are we going to drag it? Because I just don't see it.
Your Honor, our position would be that there's enough to move the case forward with probable cause. Whether there's issues for trial is another issue.
I mean, in that sense, he's right. I mean,
Yeah.
it's just a probable cause hearing. Is there enough to move forward? Because it's a very low burden, right? Yes, I agree with you. Is it enough to find someone beyond a reasonable doubt guilty? Perhaps not.
And I'm also basing my arguments as what is actually the evidence that we currently have to kind of figure out the confusion on what actually happened that night. And the videos are not clear at all, which is
Videos are not clear, so and really our reliance is on the sworn statement by the officer in the DIMS.
So let's look up, because it says here, by grabbing EMS responders' right arm, interrupt, disrupt, impede, and interfere with Sanders, a person employed to provide emergency medical services, including the transportation I'm sorry, this is what I'm looking at. Did then and there unlawfully with criminal negligence. What does criminal negligence mean? Let's look it up.
Yes, Judge.
The defendant should have been aware
This
of
is a huge moment. The judge is weighing whether briefly grabbing an EMT's arm even counts as criminal negligence. Think about it. The law requires a substantial and unjustifiable risk of harm. Does one quick emotional grab really rise to that level? The defense points out that unlike cases where gross negligence led to death, like a runaway trailer killing someone, here no harm was done, and EMS continued their work. This comparison is powerful. It forces us to ask, are we criminalizing panic or punishing actual danger? Be honest with yourself. If it were your mom on that stretcher, would you have stayed calm?
If we're gonna go that, I'd respectfully ask for maybe 5 minutes to look in case law and see.
Take your time. There's no.
Yes, Judge.
Yeah, absolutely. There's no rush here. I mean, we got, you know.
Yes, Judge. I respect 5 or 10 minutes and just to look at case law.
Absolutely.
Yes,
Take your
Judge.
time. Okay. Once and for all.
Yes, Judge. And after reviewing the video and reading case law where there's a case Duncan Telby State where they describe it as essentially shutting down, even we looked at it, we don't see that.
Okay, I'm going to find no problem.
Yes, Judge. And
All right.
yes, Judge.
All right.
Your Honor.
Good job.
Thank you. Thank you.
And I'm going to tell you, look, from what I read, I was looking at case law as well too, and it said the gross deviation is such that, like, there was a guy who had a trailer, right, who didn't put chains on the trailer detached. It was a homemade trailer. It detached and it killed someone. That's a gross
That's
deviation.
why I
You know what I
posted the
mean?
video and it was just
Yeah.
very brief. Yes, Judge.
We have enough cases.
Yes, Judge.
Thank you, Your Honor.
Thank you, Judge.
Good job.
Thank you.
So, what's the takeaway here? The judge ultimately found there was no probable cause, meaning the son's actions didn't meet the threshold of criminal negligence. This case highlights a fascinating tension in the justice system, where the law's rigid definitions meet the messy, emotional reality of family emergencies. On one side, the state tried to argue that even brief interference with EMS is a crime. On the other, the defense successfully painted this as a moment of panic, not intent or gross negligence. And the judge agreed. Cases like this remind us how much context matters, and how thin the line is between a chargeable offense and a human mistake.